Good evening. This is John Milburn for Central Queensland University. This is Laws 13010, Evidence and Proof. And tonight we're talking about a number of things, including the first assessment. We have a couple of people online. Thank you for joining us. And for those that are not joining us live, no doubt you're watching this recorded session. I encourage you to ask any questions that you have of me through UCrew. The other thing is that you'll notice that the assessment pieces are already released. They're online already, and as a result of that, I do expect that all assessment will be done on time. There's a little flexibility for the cross-examination assignment. It's due Thursday the 13th of April, technically. However, we can be a little bit more relaxed on that one. The reason for that is that there's not the specific generalised, or there's not the specific feedback that you would normally expect in an assessment. And it's important that you understand that this is something that is recorded, and there'll be feedback to you, but not necessarily to the entire class. The second assessment, the experiential assignment, is due on the 25th of May. And it's an interesting assignment. You have an opportunity to watch a movie. And like the first assessment, it's very much a hands-on experience. So in evidence and proof, what we're looking to do is gauge your ability to extract the material essence of what it is that you're trying to prove, and then go about the exercise of proving that. So the proof aspect is only relevant if you can put forward evidence that will support an argument. And the argument has to relate to the legal issues that you identify, and that's all based on the material facts that you find. So go back to your basic principles of IRAC, issues, rules, application, and conclusion. And bear in mind that we're now at a stage where we're looking to apply your legal skills, so the third, to ultimately hopefully come to the right conclusion. But in order to apply your skills, remember you've got to identify the legal issues and you need to establish the legal rules. Otherwise, it just doesn't work. Okay, so that's the way in which you should approach everything in law, particularly in evidence and proof. When it comes to the cross-examination exercise, your task is to join up in pairs, and we'll just have a look at that on the screen, and I'm going to share the screen now. And you'll see that the assessment is coming up on my Moodle page. The computer's started to run very slowly. All right, so what you need to do is form groups of 2 people. What you must do is find your own partner for this assessment. I'll make note of who the partners are, but I'm not allocating partners for people. So please find a partner that you can work with. It's not a team event in the sense that it's a group assignment. It's an individual assessment, and your role is to undertake the task of either prosecuting or defending in relation to a witness. And when it comes to technique, here's the important thing. Make sure that you have 10 or 20 questions prepared in advance. In asking those questions or preparing those questions, make sure that you follow the rules of evidence. That is, to the extent that you know the rules of evidence this early in the course. And you must submit those questions through Moodle by the due date. So that means before your task starts, or the actual audiovisual task starts, you must prepare the questions, upload those so that I get to look at them. That's important because I want to see the level of preparation, and I want to see if you have properly absorbed the rules of evidence. Now, when it comes to the live event, which is where you're cross-examining me in a mock situation, that will be recorded via Zoom. It's not generally made available. That will remain on a private setting, but I'll archive that. And the reason I do that, in the unlikely event that someone wants a to revisit any mark that I might give, there is the opportunity for someone else to review the work and reconsider the assessment if necessary. But that doesn't happen very often, if at all. Okay, so the task is that you will be a prosecutor or you'll be a defence counsel in relation to a witness, which is me. So I'm going to stop the share now and ask, firstly, what does a prosecutor do? Would either of you like to come in and answer? Just unmute your microphone.
Accuse the defendant.
What was that? Sorry, Dana?
Accuse the defendant.
Yes. Okay. And in the context of accusing the defendant, the prosecutor will ask questions, yes? The questions that the prosecutor asks are what we call open questions. And we've got someone else who's joined us. Hi, Jessica. Thanks for doing so. So open questions are used by the prosecutor in the context of questioning the accused, or the witness rather. And the open questions are a hallmark of what we call examination in chief, which is essentially what the prosecutor will do. So I'm assuming that this is a prosecution witness, in other words. It doesn't have to be. The question is a little open-ended in that regard, but I think you'd probably assume that that's the case. Okay, and the reason I say that it's likely a prosecution witness is that the police took the statement of the witness, Xavier Kelly, and we'll have a look at that statement shortly. Okay, so the prosecutor calls the witness, and the prosecutor asks questions of that witness, and we say that the questions are in examination in chief. Examination in chief is where the witness essentially gets to tell his or her story in relation to the matters that they are aware of that are relevant to the case. Now, I've just said a word there, relevant, which is extremely important in the context of this course. Can someone tell me why relevant is important? Jessica, would you mind? Why is relevant such an important word when we're talking about evidence and proof? You just need to unmute your microphone, Jess.
Are you talking to me or the other Jessica?
Oh, I'm sorry. We've got two
Jessicas.
Sorry, of course. Yes, you, Jessica. Richardson.
Why it's relevant? Why is relevant important?
Yes.
Because if it was irrelevant, then the evidence wouldn't be doing its job, wouldn't be supporting the facts, issues.
So let's assume that for the moment, assume that you and your partner decide that you'll be the prosecutor. So you call Xavier Kelly to the stand and you ask Xavier a question. Now, Xavier could be male, could be female, but you ask Xavier a question. And what if your first question was, do you have any brothers and sisters? Do you think that might be a relevant question?
Probably not, but it could be.
It could be, but probably not. So it needs to be, when we talk about it being relevant, it needs to have some bearing on the case. Jessica Fowler, thanks for joining us. When we talk about it being relevant to the case, what does that mean? What are we trying to establish by our questioning of a witness? Jessica Fowler?
Would you be trying to just draw out the case? And that's what you mean by, yeah. Yep.
So you're trying to draw out information. Now, as the prosecution lawyer, you have an advantage in that, of course, you've had discussions previously with the witness. We expect that to be the case. And in the course of your discussions with the witness, you have established certain things that you want to establish in the trial itself. And they need to be relevant facts. So when we talk about it being relevant, so Jessica Feller, we're looking to establish something that is relevant to the charge. In this case, it's a criminal matter, so it's got to be relevant to the charge, hasn't it? Okay. All right. So let's have a look at the question, which is something that I will bring up on the second screen. So the question now is this. You're to cross-examine or examine. So if you're the prosecutor, you're examining. If you're defence counsel, you're cross-examining a witness. And it relates to two people, Scott and Simon, who have been charged with robbery, and the particulars of the charge are outlined in the statement. So when we talk about relevance in a criminal law context, the first thing that I think you need to do is have a look at the exact charge, and that will come from the section of the Act, or the sections of the Act. So in this case, sections 409 and 411 robbery. If you're the prosecutor, in simple terms, your task is to present evidence that goes to establish that on 11 November 2016, Scott Drysdale and Simon Bancroft stole a quantity of cash and cigarettes, and at the time, the defendants used or threatened to use actual violence to a person. As a prosecutor, you're a model litigant in the sense that you must, you're not there to press for a conviction. What you're there to do is put the facts fairly to a court through the witness. So bear in mind that when you're doing this exercise, you must always go back to the charge itself, which would in this case be on an indictment, and try through your questioning to establish the individual elements of the charge. So what's important here? The first thing is that in your questioning as the prosecutor, you need to establish that something happened on a certain date. So that'll be relevant. You need to establish that one or two, probably two, people did something. And it's not just any people. Through your questioning, you need to establish that Scott Drysdale and Simon Bancroft were the people that did something. We then go to the next stage, and what they did is they stole. So your questioning should be targeting these elements. So you need to highlight the individual things and make sure that you're working towards extracting information from a witness that goes towards proving these essential elements. You'll recall from doing criminal law that stealing includes excluding the fact that they had lawful authority to take possession of the goods. So a trap for young players in prosecuting might be to leave the door open for defence to say, well, yes, you may have established that Scott Drysdale and Simon Bancroft had in their possession cash or cigarettes, but you didn't establish that they did so without permission, that they stole them, because stealing means without the possession of the lawful owner. But it goes beyond mere stealing of cash and cigarettes, because in order to constitute the act as one of robbery, as prosecutor, you need to establish, in addition to the taking of the items, that in doing so, the defendants used or threatened to use actual violence to the person. So you need to establish all of those things as the prosecutor. And again, let's stop the share. How do we do that? As a prosecutor, how do we establish that? Anybody want to answer? We do it through questioning. Okay, so through our questioning, we're looking to establish those elements. And the 10 to 20 questions should be the starting point for doing that. It's a tough exercise in that you probably need to go beyond, certainly go beyond 10 or 20 questions, and I'd expect that. But at least you try and identify the main points. Okay, has anyone actually read through the exercise and the statement at this stage? No? All right. So you know what I want you to do. And those of you that have worked with me before, you know this. You know that I start at the end and I'll work backwards. And that's why I give you the assessments right in week 1. Apart from the fact that I don't like assignment extensions, but you all know that by now. So you're very unlikely to get an extension of time because I'll say, well, you had the material on day 1. Okay, so what we're looking for you to do is to have the material available to us at an early stage in terms of your questioning, and that means reading the material and preparing for it now. So I'd urge you to start that process, and what you need to do is consider the basic information contained in the statement, and always, as you're reading it, cross-reference it to the thing that you're trying to prove as the prosecutor. Now, I mentioned before that when you're prosecuting, you are examining the witness. You're not cross-examining the witness. What's the difference? What's the difference between examining a witness and cross-examining a witness? Any volunteers? No? We've only got a small group, I know. I'm surprised that we don't have more, and I'm concerned that something's gone wrong. But we have our group.
Are you cross-examining because you're referring to the prosecution argument evidence as well? Whereas if you're examining, you're obviously not referring to the defence's evidence?
Yes, there's some degree, yeah, to a degree that's right. Any other thoughts? So thank you, Jessica. Appreciate that. All right, so when we're examining, what we're trying to do is ask open-ended questions that go to establish the facts that are the elements of the charge against the accused person. And open questions are ones that don't prompt or imply a response of a certain type, or don't presuppose information that has not been established through previous questioning. Okay, so let's assume, for example, that you're dealing with a case as prosecutor involving an alleged dangerous operation of a motor vehicle, and you're trying to establish that the defendant was driving a particular motor vehicle at a certain time in a certain manner. What's wrong with the prosecutor saying something like this? I put it to you, this is the defendant, assuming that the defendant has chosen to go in the witness box, which of course they don't have to do and probably shouldn't in most instances. But let's assume the defendant has gone into the witness box. I'm sorry, that's a very bad example. I'll start again. We'll start again. Let's talk about an independent witness. Let's talk about someone who was just on the side of the road who saw something. This is a much better example. So the prosecutor calls this person to give evidence at the trial, and they're trying to establish that the defendant was driving a red Commodore in a certain manner. What's wrong with the prosecutor opening the questioning of this independent witness with a question like, on the 11th of November 2016, at Smith Street at Blacktown, you saw the defendant driving a red Commodore and running through red lights, didn't you? Now, what's wrong with that type of questioning? Bearing in mind that I said you have to ask open questions. I'll have a cup of tea. Yes, Jessica?
Oh, that wouldn't be an open question because it's prompting a yes or no response.
Yes, that's the first thing. Yeah, that's the first thing. What else is wrong with that type of questioning that I put forward to you? Jessica's spot on there. There's a few other things that are wrong with it. Diana?
In the prosecutor is actually saying part of the thing that he wants to prove, the card and the brand of the card, and
Yes. Yep.
he given more details.
Yep.
Than an open question.
That's right. So in addition to prompting a yes or no response, the prosecutor is trying to establish certain things that has not been drawn out through the evidence. Okay. So Jessica Richardson-Brown, what should the prosecutor do in asking open questions of a witness?
What questions should they ask in that situation? Is that what you mean? No.
What type of question? What's the correct technique?
Where were you on this date?
Yep.
Did
You're on the right track.
yeah. Have you seen this? No, that's yes or no.
And look, a yes or no is not necessarily fatal, but you've got to be very careful. You're treading on thin ice if you start to ask questions that prompt yes or no when you're examining. All right. What I want you to do is think of a really good opening word. If you're the prosecutor, the very first word is often critical. A good word is where. Where were you? Well, you can't answer that yes or no. Where were you? Yes. Doesn't work, does it? So where were you? Oh, I was standing at Smith Street. Okay. We've identified the location. What's another really good opening word if you're a prosecutor? Where's good? What else is good?
How?
How? Yep. How did you view this event? Yes. Well, it doesn't work, does it? So if you ask how, it prompts the person that you're examining to provide some degree of explanation or context or information. So how's a good word? I like how. What are other good words to start with?
Tell me, what did you see on this day?
What? Yep. What's a beauty? What did you see? Yes? No, well, it doesn't work. So what did you see? Excellent. Mind you, you probably have to establish that they saw something before you said, what did you see? Because what did you see presupposes they saw something. So you understand that you've got to work your way back and make sure that if you're examining, you are asking an open question and you're not presupposing information that has yet to be established. So you've got to establish, it's building blocks, isn't it? Building block, one after the other. Another dreadful thing that I did with that first question is I layered it. One thing upon another, upon another, upon another, upon another, which is a dreadful way to ask. So if you're asking the questions in examination, do you think the question should be long or short, generally speaking? Short. Yeah. One concept at a time. Now, if you were defence counsel and someone said, in the exam, the prosecutor said, what were you wearing on the day of the alleged offence? What's wrong with that? No, it might be okay, but you need to establish the date of the alleged offence before you can ask, what were you wearing? In other words, it's a simple sort of question. You probably everybody knows it was the 11th of November, but you need to be careful to ensure that you set the groundwork by layering. So if you're going to ask a question about what someone was doing, wearing, seeing, smelling on a certain day, you've got to establish the day first, or the context. Also, if you ask a question such as, where were you driving the red Commodore? What's wrong with that? If you were defence, why would you object to that if it was a lead question? Well, the answer is that there are a few assumptions there, aren't there? You're assuming that the witness was driving, you're assuming that the witness was driving a Commodore, you're assuming that the witness was driving a red Commodore. So you're layering these things in circumstances where you need to establish those things first. So simple questions from the outset are important. What did you see? Oh, I saw someone driving a car. What type of car? It was a Commodore. What colour was the car? So you see that one question is easily broken into 3 appropriate questions and quite permissible questions. So when you're doing the prosecution aspect of this exercise, just be careful about that to ensure that we don't breach any rules. Okay, when we're cross-examining, we're doing something quite different. So what's cross-examination? What does that mean? Any thoughts? So examination is where the prosecutor asks open-ended questions. What do we do in cross-examination? Is it the prosecutor? Can be, but let's assume it's a prosecution witness. The prosecution has gone through evidence in chief, which is asking the series of open-ended questions. Defence counsel stands up and cross-examines. And what's defence counsel trying to do?
Pull it apart?
Pull it apart, yeah. And sometimes it doesn't have to be dramatic. It doesn't have to be, not necessarily, because the prosecution has to prove, in this case, beyond reasonable doubt. So pulling apart the witness may be much more...
Or the examination, I meant not the witness, the examination by the prosecutor.
Oh, yes. Oh, well, yeah, true. So in defence counsel, what you're looking to do is test the evidence. How good is the evidence? The prosecution witness says in examination in chief, I saw the defendant run from the scene. What sort of questions do you think defence might ask about that? And say, well, witness saw the defendant. That's all there is to it. What sort of things do you think you might ask in cross-examination? This is all very hypothetical.
Would you ask things like, how far away were you standing?
Yes, how far were you? Thank you, Jessica.
Yep.
Diana?
Maybe the time and the date.
Yes.
That's great.
Clarify the time. Yep. No, that's good. Any other sorts of things? And you've got to be a bit careful here that you go fishing for something. The general rule is you're not supposed to ask a question in cross-examination unless you know the answer. So if you're just fishing for something, that can be a little dangerous. So in this scenario that we're asking you to do, it's a bit artificial because you're just given one statement in total isolation of everything else that you might otherwise know about this case. So we'll give you due allowance for that fact. What if you find out after the trial that the witness was actually terribly drunk at the time? That may be relevant, may have impaired their visual judgment, may have impaired their memory. Okay, so just think about those sorts of things. So as you read the statement of Xavier Kelly, ask yourself, either as prosecutor or defence counsel, what do you need to establish here when it's prosecution, or what doubt do you need to cast over the evidence if you're defence counsel? And you do that through that process of examination or cross-examination, respectively. I think it's a good idea to do the exercise for both parties individually at the start. Look at the exercise and ask yourself, all right, well, if I was the prosecutor, what sort of questions would I ask? Have a list. If I was defence counsel, what sort of questions would I ask? And it's useful, I think, to look at it from the perspective of your opponent, because that may give you some guidelines when it comes to doing it from the other perspective. And all of that in the context of the charge. Always go back to the charge. Have I proved each element of that charge during my examination to the extent that you can through this one witness? Or have I cast doubt over any one or more aspects of the elements of the charge through this witness? Okay. All right. Any questions? Yes.
Yeah. Is it the defence usually would obviously not have 20. Well, they'd have some questions written, but I mean, in the assignment, our questions are going to be written before we've heard the prosecution's questions.
Yep, and that happens in real life.
Yeah. In
real life, if you're defence counsel, you should prepare your questions.
But they would change. Will they? They would be able.
Yeah.
And in the assignment, will they change? I mean, are we doing that a bit like for real situation or?
Yeah. So what will happen is that you'll have a Zoom session with me. I'll be Xavier Kelly. And Xavier Kelly is going to be different for every group of participants. So sometimes Xavier might be this, it might be that, it might be. So there'll be something that will probably throw prosecution. There'll be something that will probably throw defence. So I want you to have your questions prepared, but you need to provide for flexibility depending on the circumstances. What do we need? What particular skill do we need to ensure we have flexibility? What's the single word that I'm looking for here? Anyone? No?
I was going to go with preparation, but...
Preparation is really good. Preparation is really good. And actually, it wasn't the word I was thinking of, but I like it. And sometimes in preparing, you might have a flow chart. You might have two branches. If this, then it will go this way. So, yep, that's a good idea. Listening was the one I was after. So, as we're doing this for real, you have your notes, you have your questions, but you must listen carefully. Okay? I'll try to give you some examples on that next time of absurdness when it comes to the way in which people don't listen when they're asking questions. All right, so preparedness and listening, we'll go with those. All right, thank you. I'm just going to share the screen now, and I just need firstly to find the material that I'm looking for. If you can bear with me a moment.
Can I just, are you moving away from the assignment now?
Yes.
Are we still talking? Yeah. On the Moodle, so on UCrew, there's nothing. No one's posted anything yet. And there's no discussion forums on the Moodle site either. So I'm assuming there's no discussion going on anywhere.
Exactly.
So how are people finding their partners?
Well,
are they just emailing people they already know? I guess if it's a third year subject, then maybe there's people that have developed relationships.
Some people have started to email me saying I don't have a partner, to which I'm asked.
Well, I was looking for a forum or something, but...
Yeah. Well, let's just have a look at the Moodle site. For those that haven't worked with me before, it is a bit different, and primarily because I use UCrew. Those of you who've worked with me before, you know all about UCrew. So you're spot on. If you look at the top left-hand side of my Moodle site, you will see general discussion and you'll see Q&A, but I don't think you'll see those on your sites. I've blanked them out, so they don't exist. And the reason for that is that I want a central point where we talk to each other as opposed to, to the Zoom sessions. So you're absolutely right, Jessica. It's here in UCrew. We simply click on that link and that will take us to UCrew. If that's not working for you, please let me know. You can send me an email or contact me and we'll go from there. But here we are, Laws 13010, evidence and proof. And Selma has written to say, I'm on the Gold Coast. I want to pair up for the first assignment. Happy to communicate. And someone else is saying, I'm in Adelaide, Rockhampton. So there are a few people there that are looking for some partners. That's a good place to put it. Once you've found your partner, then contact me and we'll work out a mutual time. So you might say, look, I'm doing this assessment with X and we're available on these days, and then I'll work in with you and I'll keep track of who's partnered with who and I'll post something on Moodle. But by now, I would have expected much more activity on Moodle, on UCrew than we have already. So please, lots of questions, lots of comments. If you come across some material that you think might help others, then please post that on UCrew. So it's your chance to be interactive, to answer each other's questions, to answer questions that I have, to ask me questions, or to post your own material. So UCrew serves all of those purposes at the one time. So you're right, Jessica, we need a lot more activity there. Let's just go back to the main page and you'll see that there are some other things that I want you to consider. One of those is not necessarily for the first assessment, but the second assessment, a sample document for assessment, which I am sure I've put there somewhere. Oh, here it is. It's in week 1 and it's an assessment guide. Sample document that I've prepared. Those of you that have worked with me before have seen it. I'll just open it up. And it's a simple document that provides you with an idea of the way in which, there's a sample of the way in which I like things set out, and also to show you how to reference material. So you'll see that there's headings and some guidelines. Actually read it. It's not just there for the layout, but have a look at the content as well. All right, so that Word document is available as an assessment guide in week 1 of the material on Moodle. And there it is there. Okay, so this is a really interesting subject in that we have an opportunity to look at some movies, read some books, and in that way it's quite fun. Now, each week, I do expect everyone to post an answer to the problems. So even though I've said UCrew is where we discuss material, there is an exception, and that is that when you come up with a response to the problem, I want you to add your response in Moodle. So let's go to problem 1.1, and the problem relates from memory to an excerpt from The Life of Brian. My internet is very slow at the moment. And there's the link to the YouTube clip. And you'll see it's Monty Python and the Holy Grail. And we don't have, no one has provided any response yet. I can't believe it. I've never seen this before. We're week 2. And that's a great clip. So please provide some response there. So just click on the yellow tab, add a new discussion topic, and provide your commentary in relation to that YouTube clip. We should have 20 responses there by now. So let's see if we can move on this now and catch up some ground. Jessica, does that answer your question? Is that what you're asking?
Mine? Me?
Yeah. Yes, please.
Yeah, I haven't used UCrew before. And it has 2 scroll down bars. So yeah, I just hadn't scrolled down in the right bar to see where other people had written stuff.
Yeah, all right. So we've got that now. Everyone else okay with UCRU?
Sorted. So that's where I should find a partner.
Yes, you just asked a question. The other thing is, do you have access, I'm not sure what's on your screen, but do you have access to see who the other participants are in the course?
On the front page before you go into Moodle, on the S portal page, you have access to the class list. And it used to, though, when it was the old MyCQU, you could see where they lived as well. So now you can, but now you cannot see that.
Yeah, I think there's sort of privacy issues that are involved, but at least you have the people's name and some degree of contact details, like an email address. So you can always, you know, you don't have to.
And an email, yeah.
You can approach someone and say, look, you know, can we partner up for this one? I'm just interested in getting the names of the people that are joining up. Let me know, and on the front page, I will add a table to say who has joined up, and we'll go from there. All right, well, time is getting away from us. I just want to show you a couple of interesting textbooks. The principal text that we're using is David Field's text. This is excellent. I trust that you're well and truly into it by now. It's not every chapter that we're covering in this course, but we're covering most of it, and it's an excellent text. The other text material that you might consider, this is excellent material in relation to the rules of evidence, and that's part of the recommended reading, and that is by Aronson and Bagaric. So keep that in mind. And a very well-respected author and a leading text, which is not prescribed but highly recommended, is Evidence Law in Queensland by John Forbes. So keep that one in mind as well. That's published through Thomson Reuters. The first two are LexisNexis, Butterworth. All right, we might wrap it up at this stage. So what do we take from tonight? The first is that I've got to find out whether my link is correct.
Sorry, can I just quickly ask something? Do you recommend that we buy, print or download copies of the Evidence Act or the other one? There's two, isn't there? The Commonwealth and the Queensland.
There is, yes.
Do you recommend that we have those?
I do, but you can access those materials online and you don't have to have the hard copy. I do. I actually went a step further and went to the prescribed or the authorised printers and got hard copy evidence, so I can take it into court. But it's not a bad idea if you don't get court. Okay, so thank you for that.
Both of them? We refer to both of them?
Yep. So in the state context, we have our Queensland Act. In the Commonwealth, we have the Evidence Act, which is part of the Uniform Evidence Act for Commonwealth and a few other states such as New South Wales. But in Queensland, we have our own State Evidence Act, which is not part of the Uniform Evidence Laws. Okay. All right. Well, we might wrap it up at that. Thank you very much for your participation. So we'll find out why we didn't have more people. I'm really surprised that we don't have people online to me saying, where are you? Because I'm really concerned that we may have had a duplication of links or something silly. The second thing is that we need you to start really thinking about your questions for the first assignment. It's only just around the corner. So lots of questions for examination, open short questions, cross-examination, which is where you're trying to cast doubt, and do that exercise for both. Then try to partner up, and very importantly, two other things: UCRU, lots of activity, please, and secondly, weekly problems. Let's have some responses to that. Okay. Thank you so much for joining me tonight. I'm very pleased that you did. And unless there are any questions, we might wrap it up for tonight. And we'll see you next week. Okay? All the best. Bye.